Can schools control what students say at student protests? When is a student walkout a school-sponsored event? Jamie, what's the first rule about protesting gun violence at schools?
The first rule about protesting gun violence at schools is don't talk about gun violence. At least according to the Shawnee Mission School District. Yeah, so yes, today's case, everybody, is another First Amendment student speech case. This time, we're heading to Kansas to look at what happened when students planned a walkout and the school, well, let's say they got rather involved in that event. All right? So welcome to Chalk and Gavel, everybody, where we explore how the law shapes education one case at a time. I'm Jamie Cudlitz. I'm a former middle school math teacher and principal.
And I'm Chris Thomas. I've been a high school English teacher and a school attorney. Now we're both professors of educational leadership, bringing you the fascinating stories connecting the courtroom to the classroom.
Chalk and Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
The kids are alright. The kids are alright. The kids are alright.
Welcome back, everyone. It's just me for today's bell ringer. Jamie is still running his summer camp up in Canada, and we recorded this episode a while ago. And when we recorded it, we figured, why not do the bell ringer when it gets closer to release? So that's more timely. And we didn't get a chance to do that. So that's why I'm here. But before we get to the bell ringer, please like, rate, review Chalk and Gavel wherever you get your podcasts. You can follow us on social media at Chalk and Gavel. Check out our website, chalkandgavel.com, and support us on our Patreon. That means the world to us. $2 a month goes a long way to helping us continue to do this show. And also, because we haven't had a chance to do it yet, get ready for an extremely exciting and special 50th episode. That'll be our next episode after this one. We are so incredibly excited about it. We return to students' rights with a very special guest. Jamie and I joke that we have so much fun doing this show, but our 50th episode might be one of the best professional moments that I've got to experience. So I'm so excited to share it with all of you. So I hope you're excited. For today's bell ringer, I've got a Supreme Court double header for you. One case was decided last term, and it's one we've mentioned a few times, both either as a bell ringer or in talking to Mark Walsh about the Supreme Court and the Supreme Court update. And the other is a case that the Supreme Court just granted cert on that they'll hear next term. Both of these cases, though, involve legal protections for transgender youth. So the first case was United States versus Scrimeti, and this was a challenge to some state laws that restricted certain medical treatments for transgender youth. So things like gender-affirming care, things like that. Children, their parents, and some healthcare providers challenged the law, arguing that it infringed on parents' fundamental rights to raise and direct the upbringing of their children. I'm not sure where we've heard that one before. That was a big piece of the Mahmoud cases. And then they also argued that that these laws violated the Equal Protection Clause because they discriminated based on sex and based on transgender status, which should be deserving, according to these plaintiffs, of higher judicial protections. So gets all the way up to the Supreme Court, and in a 6-3 decision along ideological lines, the Supreme Court concluded that these laws did not violate the Equal Protection Clause. Now, what's really interesting, though, is how they decided that. As with a lot of these cases, the how tends to be really, really important. So Chief Justice Roberts wrote the opinion for the majority, and he characterized these laws as discriminating based on age and medical use, not based on sex or transgender status. And because of that framing, he kind of sidestepped, for the majority of the court, the question of how to address claims of discrimination based on transgender status. And so that was kind of what we were all watching this case for, is to kind of see how courts were going to apply the Equal Protection Clause to allegations of discrimination against transgender individuals. But because of the very kind of narrow way that the Chief Justice understood these laws, they kind of sidestepped that entire issue. And so that's still an open question. Now, there were at least three justices who expressed some skepticism that discrimination based on transgender status would get elevated scrutiny under the Equal Protection Clause. So the reason that matters is because under the Equal Protection Clause jurisprudence, the more kind of invidious the classification that we're drawing, the greater scrutiny or the greater attention courts are going to pay to making sure that those laws are justified. So at the very apex of the Equal Protection Clause jurisprudence, we've got discrimination based on race. That has to meet strict scrutiny. Has to be those laws that discriminate based on race have to be necessary to accomplish a compelling governmental interest. Below that, you have sex, and then some other things, and then everything below that just gets a rational basis review, which just means that the law has to be rational. And depending on where we put transgender discrimination on that kind of pyramid, could have profound implications. So Scrimetti sidesteps that for now, at least, but at least three justices said that they would apply the lowest level of scrutiny for discrimination based on transgender status. But that does mean that of the six conservatives who joined the majority opinion, three of them said, we don't feel like transgender individuals are deserving of heightened protection, but three didn't. So who knows which way that's going to go. But chances are we're not going to have to wait very long because of two cases that the Supreme Court granted cert on that they're going to hear next term. So Chalk and Gavel, we're not going to run out of stuff to talk about. Not that was ever really an issue. So both of these cases, the names are Little versus Hecox and West Virginia versus BPJ. They both involve transgender student athletes who are challenging policies that ban transgender women and girls from participating on girls and women's sports teams. So one of the cases is a higher ed case. One of the cases, it is a K-12 case. And in both cases, the plaintiffs argue that the bans violate Title IX by discriminating based on sex, and they also violate the Equal Protection Clause. And interestingly, in both cases, the plaintiffs were successful at the lower courts, meaning that these laws were put on hold and that these transgender individuals could compete on the teams that aligned with their gender identity. So, this is definitely something that we're going to have to follow because the court just took it up. We'll have oral arguments and an ultimate decision. We'll probably also have to do an episode on one or both of these cases at some point. So keep an ear out for that because I think Chalk and Gavel needs another Mahmoud case that we can follow from beginning to end, like we did with that case. So we will have plenty more to come on those cases and these issues. But for now, let's get back to our regularly scheduled episode.
All right, so the context for today's case is the aftermath of the Parkland school shooting in Florida. Okay, so that was Valentine's Day of 2018. All right. And as many of you might recall, students from across the country staged protests, walkouts, and other activities to voice their concerns and demand reforms, right? Regarding things, concerning student safety, gun violence in schools, all that kind of stuff, right? Like it was a horribly tragic event.
It was, yeah. 17 people killed, 17 people injured.
Yeah, it was bad.
It was. The aftermath of it, like these student protests, though. So I guess put my cards on the table. The subject of my first book, Reclaiming Democratic Education, was the student and teacher protests in the spring of 2018. So your book was what we're talking about today. The subject of it. Yeah. The fascinating thing about what happened after the Parkland shooting was just how quickly and how far these student protests spread. And so within like a couple weeks of the Parkland shooting, we had 2 national student protests already planned, student walkouts. And then this one that we're going to talk about today was the third event that started as a change.org petition by a student. And it got like over, I think, 250,000 signatures and over 2,500 schools like participated in this national school walkout. So Parkland was absolutely a tragedy. The social movement that it sparked was, really profound. Yeah. And inspiring.
Right. Because unfortunately, this is a topic that comes up way too often, and once is too many. But these kinds of situations have happened a lot since Columbine, which was in the late 90s. And not every one of those events has resulted in the kind of student movement that Parkland generated.
Right.
So this is, this is a case that we're going to talk about today that takes place in the aftermath of the Parkland shooting, just a couple of months after the Parkland shooting, and a school district in Kansas. And so what happened here is we've got this national walkout, right? It was planned for April 20th, 2018, which happened to be the 19th anniversary of the Columbine massacre.
Right.
Okay.
And that was a very intentional choice by the people organizing the National School Walkout.
Right.
Yeah.
And so for us, we're in the Shawnee Mission School District in Kansas. And it was very clear in this situation that the protests in this district were student-led. And the reason we know this is it's because it was written in the opinion. But in the opinion, it said that students informed school officials of their plans in advance, and district officials in turn notified parents. Okay? All right.
Yeah.
And in that notification, the district informed the parents of two things. The first thing that they said was students would be allowed to participate in this protest. So here's this protest, it's happening. We're going to let students participate, and they're not going to face any disciplinary actions for participating. Okay. Now, these protests were very structured. They were like, we are going to do this at the same time for the same amount of time, in places across the country. It was like 17 minutes. There's going to be a walkout for, I think it was something like 17 minutes or 19 minutes.
I think one of the earlier protests was scheduled to be 17 minutes long to commemorate the 17 victims of the Parkland shooting.
Right.
I think National School Walkout was supposed to start at 10 a.m., whatever time zone you were in.
Right.
And there's supposed to be, I think it was a 13-second moment of silence for the 13 victims of Columbine.
Yeah.
And then there was supposed to be like open mics, and most of the protests, I think, went all day.
So, back to what the district said in its notification to parents. Again, I mentioned that there were two big important things that it said. The first thing was that students could be allowed to participate without facing any disciplinary actions. And the second thing was that the student protests were not school sponsored. Okay. The district informed parents that these were student-led protests, and the district didn't have anything to do with it. The only role that they would play is they would monitor the protests for safety.
Okay.
That makes sense.
That's kind of the tricky position that a lot of schools were in and are in when it comes to student protest is like there's kind of two questions, like how involved do you get?
Yeah.
And like, how do you address that with student behavior and conduct? And then also kind of the question of like, how much do you supervise to avoid, something bad happening, or like how much control, how much influence, and like also how much supervision. And like those can cut you in different directions or pull you in different directions, because, we want to make sure that school leaders have an obligation to like kind of keep students safe and, take reasonable precautions to make sure that bad stuff doesn't happen.
But we also have this obligation to uphold the students' rights to free speech in this case, right?
Right, exactly.
And so we're doing a little foreshadowing here, sort of the two big legal issues in question here, and we've talked about them before on this show, the Tinker Standard and the Hazelwood Standard, right? So you've got the two things that Chris was just talking about. We've got the Tinker Standard, which is focused a little bit more on restraining speech when there is a reasonable forecast of disruption to the educational environment. So, so there's that piece at play.
Or threatens the right of other students, right?
Threatens the rights of other students, exactly. And then there's the Hazelwood Standard, which applies to school-sponsored speech, which basically means that if it's a school-sponsored event or curriculum or anything like that, the school has a little bit more control over what is being done and said. We're talking a little bit about the Tinker Standard and the Hazelwood Standard. We're mentioning it now just because it's not a bad thing to sort of be thinking about in the back of your mind as you listen to the rest of the facts in this case.
Right.
Right.
It's something that the school leaders maybe should have been thinking more about?
Yeah, well, here we are with a lawsuit. So
Yeah, right. Like that's
I guess
the
they
nature of
weren't.
Chalk and Gavel. Yeah.
Yeah. So, so we've got this obligation to kind of keep students safe, and we have to wrestle with, how involved do we have to be in order to meet that obligation before we sort of overstep our bounds.
Right. We got to balance that concern with student speech rights.
Right.
Yeah.
Okay. So here's what happened. All right. The district sends out this notification saying, don't worry, they're not going to be disciplined. And this is student sponsored. All right.
Which great approach. I like that approach.
So far, so good.
So far, so good. Because you can discipline students for what they do, even if you don't discipline for what they say. So like if students walk out, like you can punish them for not being where they're supposed to be, right? Like truancy.
Right. Yes.
So I appreciate the district saying like, look, we're going to create a space for them to do this thing.
Yep.
We're not going to punish them. We could, but we're not going to.
Right. So what happened after that, though, was internally, despite saying that this was not a school-sponsored event, the district directed its school leadership to prohibit students from discussing guns, gun control, and school shootings at this walkout. Okay?
Right.
So those were the issues at the heart of these protests. Right?
Right. So, like, what can they talk about then? So, like, if these protests are on the anniversary of the Columbine shooting in response to the Parkland shooting, like
the first rule about school shooting protests is
the first rule about protesting gun violence is don't talk about gun violence. Yeah. Right. Like, it seems problematic. Right. Like it seems like unnecessary censorship.
Yeah. That's the point where they kind of start to lose me here. Right.
Right.
And so apparently the districts encouraged students to keep the topic to student safety and steer the students away from talking about guns and stuff like that. So basically,
what are we keeping students safe from?
Well, don't talk about it.
All right, no.
So, but here's where it gets even more weird to me. Their explanation for this was that they were a public institution and they could therefore not take a stand one way or the other on the Second Amendment.
Right.
Okay.
And they needed to steer away from controversial topics, right?
Yeah, but didn't they just say that they're not involved in this? Didn't they just say that as a public institution, this is not our speech. This is student speech. This is student-led protest. This is not.
Yeah, right. They're kind of trying to have their cake and eat it too, right? Like this is not us, but it's enough of us that we can control what's being said here.
Yeah,
right?
And that doesn't reconcile with me very well. I don't think it reconciled with the courts either. But
it's one of those very odd. Like I understand the district. I understand their instincts here.
Sure,
right? Like,
no, I get it.
They want to be involved. They want to keep this thing on the rails.
Students are passionate about this. This is incredibly fresh. It's very highly charged. It's politically, emotionally, everything like this. I remember that at the time, and I'm sure most of you listeners remember this as well. Like this was an intense time in schools, incredibly intense.
Oh yeah.
So, I understand the school doing its best to manage what was a highly charged, emotionally, politically, whatever situation.
Right.
So here's how this stuff played out in a couple of the schools in the district. So we've got some stuff that happened at a middle school and we've got some stuff that happened in a high school. All right. In this district. So at one of the middle schools, one of the APs started interfering with student speeches. So one student commented about shootings and gave some statistics, and the AP basically said, listen, hey, that's against the rules. And if you can't comply with the rules, about no gun talk, you're going to be removed. And the AP went as far as actually confiscating the written speeches of another speaker that had planned on talking about something about guns and shootings. Yeah.
So this is during the walkout. So we walk out, we're still on school grounds, right?
Yes.
Okay.
Yeah,
so,
I believe
and then
still
there's a microphone and students are kind of giving speeches and it's kind of like an open mic.
Yeah.
kind of protest kind of thing. Okay. But there's an AP kind of standing right there
Mm-hmm.
who is censoring the content
Yes.
of the student speech.
In the
Okay.
moment. Yeah.
Yeah. Okay.
So one of the plaintiffs in this case, MC, she was an 8th grader at the school, at the middle school, and she helped organize the walkout. And like others, she was told she wouldn't be disciplined for participating. And MC was the 3rd speaker. So MC gets up there and MC makes quite a statement. MC in her
I
opening,
can already tell I'm going to like MC.
yeah, you're gonna like MC. So she basically opened up her speech by calling attention to the school's directive limiting what she could talk about. Okay.
Good.
And then she said, the real issue here is gun violence. So she basically said, they don't want me to talk about gun violence, but the real issue is gun violence.
Okay.
Well, the AP
That
was
went over
not,
well, I'm sure.
Yeah, not happy about that. And MC was asked to step down, and she did. She complied without protest. She stopped her speech and stepped down.
Okay. Like in the middle of the speech too,
in the
right?
middle of the speech. Yeah.
Okay.
And then it gets better because the AP was just like, screw it, let's shut it all down. And so
because you guys aren't following the rules.
I guess. So the AP just said, we're done with this whole thing. Everybody back inside.
Okay.
There was still time remaining in their planned protest. They had,
Right.
you know,
Okay,
remember
yeah, 'cause
they had informed the administration, we're going to be doing this from 10 a.m. to 10:17 or whatever it was, the 17 minutes. And they didn't get that far before it was shut down. Okay.
Okay.
Now, some students said, hey, we still got time on the clock here, so we're going to stay outside and protest. Well, that also didn't sit
So they're
right.
protesting they're protesting the end of the protest.
The abrupt end of the protest. Yes. So that also didn't sit right. So the AP directed everybody to go back inside and even pushed a number of students towards the door. So this,
Hey, that sounds like a battery. Remember we talked about that with that other case? Right?
I agree. So it just seems like they're digging themselves deeper and deeper into some legal gray area that they might not want to be in.
Right. And my joke about protesting the ending of the protest, like that highlights a common thread through a lot of these cases like this, where like you make a bad decision and then you double down on the bad decision.
Yeah. Yeah.
And it just spirals from there because it just compounds where like it all could be avoided if you just rode the wave at the beginning and didn't try to shape it into something that felt more comfortable or whatever it is.
No. And so the icing on the cake in this middle school situation is that students were told that they would be suspended or otherwise disciplined for participating, including MC was told that.
Okay.
So, you know, again, they're just doubling down on the things they shouldn't be doubling down on.
Right.
So let's go over to one of the high schools in Shawnee at this point. Similar stuff happened here. So the one, you know, they had their planned protest for the time. They all went outside. They were all told, you know, you can't talk about this, blah, blah, blah. In this case here, the students who were speaking did comply with the request to limit their remarks to general safety topics, right?
Okay.
But after the protest, more than 100 students decided to remain outside to talk about the unapproved topics.
Okay. So there was an after protest.
There was an after protest. Yes.
Yeah. Okay.
So the administration in the high school permitted the students to do this. They said, okay, you know, go ahead and do this, except for all of you people over there who were the student journalists.
Oh.
Yeah. They told the journalists to get back to class. Now,
and they're covering the event.
One of the journalists, SW, was covering the event, and the AP at the high school approached SW, told her to go back inside, and also hand over her camera that she was using to document the event. All right. Now, the camera was the school's camera.
Oh, okay.
It was district property. It had been signed out to SW for the year for student journalism purposes.
The entire year.
For the entire year.
Okay, so it wasn't just like I took this out for this protest.
No, she had the camera for the whole year.
Right. And we're in March at this point. So
Yeah.
like she's had it for a long time.
Yeah. There was another student journalist involved in the protest, more on the protest side than the journalism side. But she was denied the opportunity to hear many of the messages during that protest as well.
Right. And I think her critique there was like basically the don't say gun rule.
Yeah.
Right.
Yeah. And she brought her concerns to a school board meeting. And at that meeting, apparently the superintendent apologized and mentioned that he would review the incidents. Okay.
Okay. That
And
seems like a legit response.
Yeah. And so here's where things start to get even funkier. So the ACLU got involved, sent the school district a letter basically saying, hey, man, you guys overstepped your bounds here. You need to remedy this situation.
Right.
Okay.
Yeah, this was a student protest.
Yeah.
And you all censored them.
Yes.
Yeah.
So the superintendent investigates, apparently personally. He's going around and interviewing students.
Oh.
So
How big of a district is this?
yeah, so it's not a small district. According to the interweb, it has about 27,000 students.
Oh, wow.
It's the third largest in Kansas, third largest district in Kansas. So it's not a small district. It says 34 elementary schools, 5 middle schools, 5 high schools.
Gotcha. So the superintendent has lots of stuff on their plate. Like
Yeah. So, but they're going
investigating
around.
this is,
Yeah.
I mean, like that's a big deal when someone that high up is looking into it.
Yeah. So, I mean, I think the big takeaway from these investigations is that the superintendent did not seem to be very. My interpretation, based on reading the opinion, is that the superintendent didn't seem to be all that interested in the students' side of events and was more interested in highlighting the positive efforts that the district made throughout this whole process. So, for example, the superintendent met with SW, the high school journalist. She expressed her disappointment that her camera was taken, and the superintendent basically shrugged it off and said something like, well, why didn't you just use your phone? Similar
Misses
to
the mark a little bit.
Yeah, a little bit. Similar thing with the other high school journalists. It was kind of like a shrug off and basically said, listen, there's a lot of, when the student tried to talk about censorship and all that stuff, the superintendent was like, there's lots of gray area in the law about what we're permitted to do and whether or not this actually violated any rights. And according to the opinion, the superintendent kind of made it sound like he just wanted to get more dirt on other disruptive students rather than engage in a dialogue about censorship.
Okay. Yeah. And
So-
part of that might just be his institutional position, right? Like, you know, he's the superintendent of the district, not the superintendent of the students.
Yeah.
Yeah. And
You
I think
know-
also at this point, Jamie, it's important for us to kind of say like this version of events is, because of the procedural posture of this case, is just based on the student's complaint.
Yes. So
you
we don't know what the, we don't know what
like everything we're talking about is just based on what the students said happened.
yes, exactly. We don't know the school's version of that, of the situation.
So it sounds like the students didn't get much closure from the superintendent or the school district then.
No. And apparently like the superintendent went back to reported back to the board and said things like, first of all, let's begin by talking about all the things we did right. Right. And didn't seem to want to spend too much time dealing with the issue because graduation was closing in and things were busy. And he said, yeah, I'll look into this more after school's out.
Okay.
And
so it's not a top priority. Let's say that.
It doesn't seem to be. Apparently, when he was asked about any trainings for school district leadership on First Amendment issues, the superintendent basically said that he spoke to multiple attorneys and 2 outside agencies about doing a panel discussion, quote, because as you can imagine, our attorneys make money on having varying opinions, unquote. I mean, I don't know about you, man, but that just doesn't feel helpful to me.
It feels, I'm all for using humor to diffuse a situation. But it feels a little overly dismissive.
Yeah, well, that's my point. Like, listen, you and I are all about finding humor wherever we can find it in some of this stuff.
Right.
And I'm not laughing.
No. That one wouldn't land with me.
No. All right. So those are the facts. And what happened, Chris?
The students filed a lawsuit.
Okay. Excellent.
Yeah, I mean, the ACLU was already involved and they didn't seem to be getting what they wanted out of this whole thing. And they didn't seem to be getting much traction with the district. So the 3 students filed a lawsuit in federal court because their core claim was that the school officials violated their First Amendment free speech rights.
Right.
They also brought a claim under the Kansas Student Publications Act, which offers some additional legal protections to student journalists in Kansas. So there's we talk about the Constitution kind of sets the baseline.
Yeah.
States can offer more protections than the constitutional minimum if they want to. So Kansas apparently has this law that protects student journalists more than they would be under the federal First Amendment. So,
great. Okay.
Cool on Kansas.
There you go. Okay.
So students filed this lawsuit. And the school district obviously disagrees that they did anything wrong because they immediately file, Jamie, your favorite.
Hey, it's a motion to dismiss. It's a 12B6.
It's a 12B6 motion to dismiss for failure to state a claim.
There you go.
Look at that.
Nice.
You could ace civil procedure.
All right. That's good to know.
It's a tricky class.
My wife would kill me if she said, if I told her I was going to go back to school again.
You don't want to go be a lawyer?
I have so often thought about getting my JD. But
you basically already have it from doing the show.
I think I could do okay in a few of the classes, the constitutional law classes, and now obviously civil procedure. I could probably.
There are other rules.
There are.
Yeah, no, I mean, like there's at least 11 other rules that come before Rule 12b6.
But are they as awesome?
They apparently just don't come up as much in Chalk and Gavel.
Yeah.
But regardless, so Rule 12b6, motion to dismiss, it's made very early in the process. And the school is essentially arguing that there's not enough here to plausibly make out a case that the district violated the law. So that's the standard, plausible. The students have to make plausible claims. They don't have to be likely. They don't have to be proven. They just have to be, you look at it and you say like, yeah, that could have happened. Or yeah, it's true. The students allege that there was a violation of their rights.
Yeah, I totally understand what you're saying. But the face I'm making is because the school is basically saying there's nothing plausible here. I'm saying there's nothing plausible about the law and the violation of the law.
Right. Because even if they're saying, even if you accept those facts, they don't show a violation.
Yeah. Yeah. There's no plausible violation. And this face is.
You seem skeptical of the school's claim.
Yeah. I'm very skeptical because I just read through all the facts and it seems like there's a lot of plausible stuff in there.
Yeah, but
anyway,
you gotta tease
let's
out
let
the
this
legally
play out.
relevant facts.
Okay, so how did it tease out?
Right. So we kind of already gave it away. The court kind of agrees with you, Jamie. Like they kind of look at this and they have pretty much the same reaction as you. Like
nobody ever asked.
Sure. So the First Amendment, right? That's kind of the primary claim here. So with most of our cases, and Jamie, you already kind of alluded to this, like the most important question here is basically what bucket does this speech fall into?
Yeah.
Which category of speech is this?
Hazelwood or Tinker?
Exactly. Yeah. Right. Yeah. Because in schools, the First Amendment protects expressive activity from governmental interference. But in schools, we have these differing standards based on the kind of speech at issue.
Right. And the mission of the school and the fact that the school has to, carry out its educational sort of objectives and things like that. So it's a balance, right?
Right. Yeah. And we've talked about a number of these standards and exceptions and things like that. So like, you've got the Tinker standard, which applies to pure student speech. And that says that schools can only prohibit pure student speech if it is reasonably forecasted to cause a material and substantial disruption or invade the rights of other students. Mm-hmm. So that's our Tinker standard, pure student speech. And this looks like pure student speech, right? These are students protesting on matters of public concern that they have direct connections to. They're student journalists. Like there's so much here that would say that this is pure student speech.
And on top of that, the other factor, which is the Hazelwood standard, right? Which it almost, in this case, reinforces that we should be looking at the Tinker Standard because the school said, this is a student-sponsored thing. We are not, as a school district, we are not sponsoring this. And so they've basically taken themselves out of the Hazelwood bucket.
Well,
right?
You would think that, but the school is arguing that we should be in the Hazelwood bucket. So Hazelwood applies to school-sponsored student speech.
Yeah.
And it basically says that schools can censor school-sponsored student speech as long as what they're doing is reasonably related to a legitimate pedagogical interest.
Okay, so help me understand how the school...
I can lay out the school's argument for you.
Yeah.
So the school is arguing that this is a school-sponsored activity. That might not be what they called it when they sent out that letter.
They said the opposite.
Maybe. Who am I to say? The school is arguing that this was school-sponsored because the speech occurred during school hours, on school property. The school allowed students to attend. It was supervised by district personnel. The timing was determined by administration. They said from 10 to 10:17. They said there were sanctioned and unsanctioned parts. So like the fact that there was an unsanctioned part implies that the sanctioned part was a school-sponsored activity. And they argue that the administrators exercise substantial control over the events, as evidenced by the fact that one of the administrators ended one of the events 9 minutes early. So that middle school protest where that AP came in and cut it off and ended the event, like they're saying that shows that this was a school-sponsored event because we controlled it. Of course, that is also evidence of violating students' rights if we're in the other bucket.
Yeah.
So like, it's kind of a double-edged sword here.
Yeah, I see that.
Yeah. So the students, obviously, for their part, say none of that makes this school speech because it was student initiated, student led. Students were the ones talking.
Yeah.
The school just basically said, go ahead and do it, and we won't stop you or won't punish you.
Yeah.
And so, the students are making that argument that like the district wants to have its cake and eat it too, because it said this is not a school sponsored event. This is a student led event in kind of the public messaging. But here they are trying to, distance themselves from what students are saying, but also like be involved enough to control what students are saying. So obviously that seems contradictory, and the court doesn't buy the district's version. And the court concludes that, yes, this is, it's very plausible that this was not school sponsored speech. Yeah. And then the court also looks at the student journalist's claim and says like, Hazelwood was about a school newspaper, but even under Hazelwood, we need to look at kind of how the school runs the school newspaper. And if the school runs the school newspaper in a way where it doesn't necessarily have substantial control over the content, like then that too the journalists' claims could also fall under Tinker rather than the Hazelwood. So like even that claim on the student journalist side is, it's plausible that we could also be in the Tinker bucket for that one too.
Yeah. And I think it's important at this point to kind of highlight a little bit of the Hazelwood standard. So it was a school newspaper case from the 80s. And, just because something might be school sponsored doesn't give schools blanket authority to control anything and everything in those things. That's an important piece to kind of remember is this. Hazelwood gives schools more authority to control what is said in these school-sponsored publications and things like that, but it doesn't give them complete authority. And so when it comes to things like, you can't censor something just because you disagree with the idea. And just because it's in the student newspaper doesn't give you the full authority to censor that just because you don't like it or you don't agree with it.
Right. You still have to have a valid educational reason.
Exactly. It's
and
like pedagogically, developmentally inappropriate or something like that, right?
Right. Yeah. And that came up in our discussion of the student compelled speech case. So Evans versus Hawes, right?
Yes.
Like where we had this student who is saying, I shouldn't be forced to do this. And the court said like, okay, well, the curriculum is school sponsored speech. So we're going to apply Hazelwood. And what's the legitimate educational value here? school necessarily didn't have a chance to kind of prove that.
Right.
But that was kind of the standard that they looked at for that. So it is important to recognize that, just because it's school sponsored does not mean you have full authority to do anything, because there's still student speech wrapped up in all of that.
Right.
Yeah. So based on all of that, the school didn't win their motion to dismiss, right?
Yeah. Because the court basically said, no, these students have a plausible, it's plausible that their rights were violated here.
Right.
Yeah.
Yeah. And applying the Tinker standard, right? So the court applies the Tinker and said okay, well, did you think there was going to be a material and substantial disruption? And nowhere did the school justify anything based on a threat of disruption or invading the rights of others. Their justification was on avoiding association with controversial topics.
Yep.
And they said they couldn't be seen taking a side. And, the validity of that aside, that's not what the standard is, right? The standard is material and substantial disruption. You've got no evidence of that. You've got no reason to believe that this would disrupt anything. You just censored it because of the messages you thought they would do. And that is a big old no-no under the First Amendment. So the court kind of concludes and says this is an example of speech that the school tolerated, not that it's sponsored. And because of that, this is very plausible that this is pure student speech and that the students are sufficiently alleging a violation under Tinker. So the First Amendment free speech claims can move forward. And that's pretty much it. I mean,
so where are we with this case? When was this ruling? And
yeah. And the fun part is I actually have that information, right? So we actually know what happened next, because this decision came out in January of 2019. So the court said that the First Amendment claim can move forward. There was a question about qualified immunity in here as well that was partially successful in getting the superintendent removed from some of this.
Yeah.
And the Kansas Student Publications Act claim could also move forward. So there was still stuff going on, even though there was some qualified immunity stuff in there. Okay. So that comes out in January of 2019. A couple of months later, in March of 2019, the parties agreed to settle the lawsuit.
Oh.
And interestingly, the settlement explicitly said that the terms of the settlement shall not be confidential. So we actually know what's in them.
Okay, so
here you go.
Spill it. Yeah. What's the tea? As the kids say,
plaintiffs received a grand total of, you ready for this?
I'm ready.
$1 in damages. But that's not the crux of the matter here. Is the settlement requires the district to train all of their administrators on the First Amendment rights of students. It requires the school to apologize to the affected students. It requires the school to adopt new policies for non-school sponsored events and to adopt a policy that student journalists cannot be denied access to on-campus events that other students are able to go to. And it says that student journalists can't have their equipment confiscated just because they're student journalists. And then it also requires the school district to pay the students' attorneys $40,000 in attorney's fees and costs associated with the case.
Okay.
And that is in addition to the $36,000 or more than $36,000 that it was reported that the district had already spent on its own attorneys. So, the nominal damages.
Yeah.
That's just to kind of you need some damage. You got to allege damages, right? And so the grand total here is a lot of training, a lot of policy changes, as well as
reimbursement for legal fees and things like that.
So this all cost the district upwards of $76,003.
But that's just for legal fees. All of those policy changes that are required as a part of the settlement, the increased training and all that stuff, that's going to cost the district quite a bit as well.
Right. Yeah. And it depends on how they do the training, all of that. I mean, man hours, attention and all of that.
Yep.
And I think the systemic reform stuff, that seems really valuable too, to the students, right?
Well, that's what I was going to say is this is the kind of stuff that when there's a settlement in a situation like this, I like to see this stuff as opposed to alternatively, if the students in this case, the plaintiffs in this case, got lots and lots of money, but the district doesn't change its ways, that's potentially more problematic to me, because what's going to prevent this from happening again? Right. And that's, and that's one of the things that I like about these kinds of settlements is that when the plaintiffs in this case are basically saying, like, just pay us back for all the stuff that we spent on lawyers, as far as everything else is concerned, do better.
Right. Yeah. Make sure it doesn't happen again.
Right. Like,
yeah,
that to me is reasonable.
Yeah,
anyway.
Yeah. I mean, I think probably the hardest pill to swallow was the required apology letter.
Yeah.
Which I actually I saw a copy of it. Do you want to know what was in the apology letter?
Go for it.
Sure. So it says, it's from the superintendent, and it says, on behalf of the Shawnee Mission School District, I want to express my sincere and heartfelt apology to you for incidents that took place around the April 18th, 2018 National School Walkout. First thing, got the date wrong.
Yeah.
It was April 20th.
Yep.
Neither here nor there. This was the year later.
Well, I would say it wasn't a very thorough investigation. So,
Yeah. Some attorney should have caught that. So it goes on to say that as educators, it is our responsibility to help our students find their voice, and our actions last spring, as detailed in the settlement agreement, fell short of that expectation. We are committed to working with students to support their First Amendment rights to free expression, and will support that commitment through Board of Education policy and staff training. And that is the entire letter.
Okay. Short and sweet.
Short and sweet. I like that phrase. It's our responsibility to help our students find their voice.
Mm-hmm.
I really, really like that, because it highlights the educational values at play here, right? Because so much of when we're talking about student speech is people concerned about the disruption or the effect that that's going to have on education and the district's desired kind of educational goals. But that phrase, it's our job to help them find their voice, shows that there's educational value in the student speech, the student protests themselves, right? Part of being a citizen is engaging in this kind of public dialogue. And so teaching students or giving them opportunities or spaces to do that, really kind of highlights that there are educational values on both sides of this. And I think that statement really kind of emphasizes that, look, we need to respect students and the educational value of student protests at the same time as we try to protect and maintain a sound educational environment and ensure student safety. We got to figure out how to do both of those at the same time.
Well, and I think it goes one step further too, than just saying we have to respect this and we have to, basically provide a space for this. It's saying we have a responsibility to encourage this. We have a responsibility to promote that, to encourage that, right?
Right. Yeah. To help students develop that. So it's not a passive thing. It's an active thing.
Yeah.
Yeah. No,
so,
I love that.
Yeah, that's great. Well, good case. It's nice to come back to a good old-fashioned student speech case. What's our homework, Chris?
Your homework is to continue to help students find their voice and to help us find our voices in Chalk and Gavel by liking, rating, reviewing, subscribing to Chalk and Gavel wherever you find podcasts.
Yeah, helping other people help other people find our voice.
Right. Yeah. elevate our voices. Help us find our voices.
Yeah.
So like, rate, review Chalk and Gavel. It's so helpful for us to continue to spread the word about the show. You can find us on Patreon at chalkandgavel.com/Patreon. Or no, that's
Patreon.com/chalkandgavel.
That's the right one. You can find us online at chalkandgavel.com, where we have links to all of this stuff, including our teaching guide and a feedback form. So if you have thoughts about the show and you'd like to connect with us, please find us there. You can use that teaching guide to incorporate Chalk and Gavel into your classes or your professional developments, or just to find an episode on a topic that you're interested in.
There you go. All right. Well, that does it for today's episode, everybody. We'll see you again in 2 weeks. Have a good one.